My name's Stephen Brown. I'm one of the directors here at Lynn & Brown, and it's my pleasure to introduce Elise Martin to you this evening, who is doing the presentation on estate planning. Elise came to us in January this year after having been admitted 6 years ago, and her background is in commercial law and estate planning. So I believe that the experience she has in commercial law is a real good asset for her estate planning, and that is the area in which she works at Lynn & Brown in, particularly because it gives her knowledge of our business clientele about what their business succession planning requirements are, and she brings that knowledge and skill base to dealing with their personal estate planning, which she's going to manage and speak to us about tonight. So extremely experienced and qualified in the area, and I would like to hand the floor over to you, Elise. Thank you very much.
Sorry?
Your badge.
Oh, this one?
Take it.
Thank
We now know who you are.
Okay. So I'm Elise Martin, if you hadn't got that. Thank you very much, everybody, for coming. We appreciate you taking time out of your evening when you could be at home or doing something else. But thank you very much for coming to the 12th chapter in our Business Insight series. We've got up here that we're talking about personal succession planning in our Business Insight series. Now, that might sound contradictory to a couple of people, but your personal succession planning is important for anybody who is in business to make sure that your estate would be dealt with in the manner that you would want, as that could have some impact on your business. Before we get started, I've just got a couple of questions. If you could all indulge me with a raise of hands. Who here has created a will in the last 3 years or updated an existing one? Okay, more than I thought. That's excellent. Most people in Australia, when I say most, I mean over 50%, don't have a current or up-to-date will. A current or up-to-date will means that you've taken into consideration how your circumstances have changed since you last made your will. Whether that's children have grown up, you've entered into a new relationship, exited a relationship, or your dog has died. Sorry. Cat. Screen fence black. It's okay. Okay. Has anybody here heard of death duties or probate taxes? And if so, who thinks that they are applicable in Australia? Does anybody have... We're not quite sure what I'm talking about. That's okay, because I'll go through that shortly. But it is quite a common question that I get. How much is my estate going to have to pay in tax? Finally, has anyone here been an executor of a will before, or do you know if you've been named as an executor? A couple of people. Okay, great. Hopefully we'll give you some guidance today as some information that you can take away with you and put to use. Or if you've already been an executor, I'd really like your feedback at the end with any questions that other people may have. If you have any questions as we're going through, please feel free to stop me. Don't wait until the end. I'm quite happy to answer them as we go while they're fresh in your mind. Talking about succession planning today. We're going to cover what makes up your estate, so what assets that you have are in your estate, how to protect and preserve your estate for your nominated beneficiaries, and also some issues with not having a will, and I've got some examples there for you. When people think of succession planning, the first thing they think of is a will. In Western Australia, your will has to comply with the Wills Act, and in each state in Australia there is a separate Wills Act. They're quite similar, but it is important that if you completely move state, move all of your assets, that you consider having a new will prepared, because the old one may not be up to date and valid. You have made a major life change by moving to a different state. It's always good to check. Your will must be in writing, and it needs to be witnessed by 2 people. These people have to be independent and should not be named in the will at all, or related to people who are named in the will. If they are, there may be some concerns as to the validity of the will or whether there was any duress entered into when the person was actually signing the will. So if you're named as an executor of the will, it's a good idea that your husband or wife or partner is not a witness to that will. And similarly, if you are a beneficiary of a will, nobody who's related to you should be a witness, as there may be an issue as to whether that gift to you is valid. There are some key clauses that should be included in every will. We should start off by revoking all former wills and testamentary dispositions. That sounds very formal, and it is, and there's a reason for that. We need to be clear that the document that we're now signing is your last will. If we don't include a clause that revokes any former wills, there might be ambiguity as to whether a previous will dealt with another piece of property. For example, if I had a will where I say, I give everything to my husband and then to my children, but in a previous will, I've said that I want my grandfather clock to go to my mother, and not mention that in my other will, there may be some confusion as to whether I still want my grandfather clock to go to my mother. You need to appoint an executor, and that's a person who will manage your estate and act in your shoes when you've passed away. The executor is an important role, and you can appoint a family friend, a relative, or an independent person. If you appoint an independent person, such as a lawyer, perhaps you're an accountant, or a trustee company, such as Perpetual, or even the public trustee, you need to make sure that you let them know and that they've agreed to act in that manner, as they may not consent to it. Additionally, for example, if you would like Lynn and Brown to be your executors, we're more than happy to do so, but we do need to have our fees paid for. Additionally, you need to distribute all of your assets. This is important so you don't leave part of your estate not dealt with. If we only distribute part of our assets, we may become partially intestate, which is when the Administration Act applies. I'll go through what happens with the Administration Act a little bit later, but there are two separate ways of dealing with estates in Western Australia that need to be proven by the court. The first is a grant of probate, which happens when you have a will, and the second is Administration Act and letters of administration. If we don't distribute all of our assets, we may seem to be partially intestate. Or if we are very specific about our assets, we might find that when it comes time to proving our will, we don't have that particular asset anymore. We've previously had a situation arise where a client gave a particular bank account to one nephew. Unfortunately, when the person passed away, they'd changed their banking structure and they no longer had that bank account. Therefore, this bank account, which should have been the main asset of their estate, no longer existed, and their main beneficiary got nothing. It's important to know what makes up your estate. This is important for you personally and also in your business. The table on the screen here has a table which includes some assets which may form part of your estate. Your personal property, which includes things like your tools, furniture, clothing, jewellery, even a motor vehicle, will form part of your estate. The next few things on the list are in both columns, and this is where it gets a little bit tricky sometimes. If you own bank account, real estate or shares as joint tenants or together with somebody or a number of people, these things won't form part of your estate, but they will pass to the last surviving individual. Therefore, it's important to know how you own your assets so that you can make appropriate decisions as to who you would like to benefit from your estate. Superannuation and life insurance are a separate beast all of their own and could take up an hour or more of your time discussing. Superannuation generally will not form part of your estate unless you're with a superannuation where the trustee, for example GESB, requires that any assets, any death benefits that they give out, they will only pay to an estate. However, most trustees, for example Australian Super, will take into consideration who all of the potential beneficiaries are and then make a decision on that basis. Life insurance, again, depending on whether it's through super or a separate insurance policy, and whether a person has made a nomination as to who should benefit from that policy, could fall either in or outside of the estate.
Sorry, can I ask a question?
Yes.
Just back on superannuation. Most superannuation funds ask you to nominate a beneficiary.
Yes.
What's the validity of the nomination?
Depending on whether the nomination is a binding nomination or a non-binding or just a nomination, will depend on whether the trustee has to.
Don't ask it.
Essentially, there's two types. One, the trustee has to make that payment to, if you've nominated a dependent, according to superannuation legislation. For example, in my superannuation fund, I've made a nomination that my husband receives my estate as far as my super goes, and that's a binding nomination. If I'd nominated my cat, that would be invalid. So although it's a binding nomination, the trustee wouldn't have to pay attention to that because I can't give it to my cat. However, a lot of superannuation funds are only starting now to introduce binding nominations. So you may previously have been able to nominate who you'd like to receive that. And most of the time the trustee will pay it to that person unless there's somebody who they think could benefit from it more. So it's important to figure out as to whether your super fund lets you make a binding nomination. And if so, then they are bound to make that payment to that person. Your trust assets and company assets don't form part of your estate. It's a very common scenario that I have where I have an individual come to me and say, I would like to give this property to that person, this car to another. And then when we actually look at what the person owns, they don't own that property. They don't own that car. A company which they run all their business through does, but it's them running the business, so they consider it to be their asset. So it's important to know whose name is on the ownership documents, whether that's a certificate of title or your registration papers, but you can't give away assets that aren't in your name. That being said, if you've got units in a unit trust or shares in a company, you can give those away. We'll go through those a bit later. It's important to know that whether you own assets as an individual or with somebody else, as this will affect your estate planning. For the next few slides, we're just going to go through a couple of ways of protecting your assets, and whether you do that through your will by use of a testamentary trust or through structures outside of your will, such as a discretionary trust, unit trust or company. Testamentary trust. This is a trust which is set up through your will. It only operates and only comes into effect when a person dies. So a common question that I get is, well, if I put in a testamentary trust now, but then I live for the next 40 years, what's the point of that? And what do I have to do with the trust? A lot of people don't realise that it only actually starts or becomes created when a person dies or passes away. So that's one thing that clients are glad to hear, because they don't want to do an extra tax return or have to do any more work whilst they're alive for the benefit of their beneficiaries. A testamentary trust does allow for income splitting, and it allows, as we have a class of beneficiaries within a trust, such as a discretionary trust, which you may be familiar with. Similarly, we have a class of beneficiaries. It is a lot narrower because obviously we only want our family to benefit from our assets in our will. Maybe. So we could distribute, if we set up a testamentary trust and that our son or daughter was the primary beneficiary of that trust, they could potentially distribute money out through to their spouse or their children, depending on their situation. It's a way of protecting your assets for your family and making sure that they're kept within your family. A testamentary trust that's created can assist in the protection of assets against bankruptcy, so that if there is the situation where someone does become a bankrupt, they could potentially still have their family home to to live in if it's left to them through a testamentary trust. It also provides a vehicle for persons with a mental illness to be able to be provided for and money able to be used for their benefit without them having the control over it that they would not be able to have, or that money being kept with the public trustee, which may not be what is the best for that money. And it also allows, in some situations, to protect assets against family breakdown situations. So depending on how the trust has been used and when it's created over the course of a relationship, it may be able to quarantine assets away from a family property dispute or hearing in the family court, which is a great way of considering and protecting your assets for your family and your future generations. There can also be tax advantages to including the assets within a testamentary trust, and again these can be benefited through income splitting and the investment vehicles of your trust. Discretionary trusts, unit trusts and companies, as we mentioned, are all things which do fall outside of your estate, but with proper planning you could use these vehicles to benefit your beneficiaries. Recently we have had a client come in who has a business. That business is also run by one of their children, and they have decided that they would like to give the shares that they own in their company to that child. They're not going to provide for that child in any other way through their will, because they want to give them only the assets and the benefit of that company. The rest of the estate, which is their personal property, their home, their bank accounts, they are distributing through their other two children. And when it works out, all children will receive a good inheritance from the estate. But by giving the shares to one child, it means that that child that is running the business still is able to do so without having input or potentially unhelpful requests from their siblings who have nothing to do with the business and have no interest in it now. It's important, as I mentioned, it's important to consider how your assets are structured during your life. And using the discretionary trust as an example, I previously created a trust for a client who wanted to ensure that a beneficiary who did not have full mental capacity at least had somewhere to live without being concerned about what their other children might do or might try to take advantage of this child. We created a discretionary trust that provided that the beneficiary of that trust was the child and their children and grandchildren and so on, but removed any ability of their siblings or any other persons of the family to be beneficiaries of this trust. This meant that the client was sure that although somebody else would be managing this property for their child, the primary beneficiary and the real person that it was meant for would have access to that property without it potentially falling in as part of their estate and then having to be split or divided between the other children. Additionally, with your real estate, so your personal property, your home, it's important to consider whether you own that as joint tenants or tenants in common. Joint tenants is where you own it together with somebody. If one of you passes away, the property will just pass to the other one. Tenants in common is where you each own your respective share, whether it's 50-50, 70-30, whatever it is, you own your share of that property. I've previously done a property restructure for a client where they own the property as joint tenants. They wanted to give their share of the property to their respective families. This was a second marriage, so we had children from previous marriages that we needed to consider. By restructuring the property and changing it from a joint tenancy to a tenants in common ownership, it meant that husband and wife could gift to their own children their half of the property. It also meant that we included a life tenancy in their will so that neither of them was kicked out if the kids wanted to take ownership of the property and sell it. But knowing this and going deeper and doing more exploration as to how the clients own the assets is really important, as they sat with me and told me, yeah, I own half and I own half. And they put in half of the money each, but they didn't realise and they didn't understand the way that they had bought the property meant that they couldn't give their half to their children. Does anyone know what happens if you die without a will? What happens to your estate? Anybody?
Amount, doesn't it?
Does depend on the amount.
And then it goes into probate.
Goes into letters of administration, but similar process. Essentially, if you die without a will, Lara's exactly right in that depending on the value of your estate, depends on what happens to it. The Administration Act applies to tell us what happens to it. If there's a situation where the Administration Act applies, you have no choice as to who the beneficiaries are. Depending on the value of your estate will depend on who the beneficiaries are, and depending on who survives you will depend on who the beneficiaries are. So for example, if you have no children, brothers and sisters, nieces and nephews, depending on your situation, will depend on who your beneficiaries are, and you may not want those people to be your beneficiaries. There's additional requirements that your family will have to go through, or your executor, if it's an independent person, and they will need to get consents from all people who could be beneficiaries. Now, if there's a falling out in the family or family members who aren't known as to where they are, this can obviously create problems and complications, time, expenses for your estate. I've got a couple of risk stories for you now. Clients that we've dealt with that have either not had a will or not had a valid will. The first one is a situation which has arisen recently for a client of ours. A will was prepared. We've got some concerns as to whether the will maker had testamentary capacity. This arises because her assets and she was under a guardianship and administration order. The public trustee was managing her finances and making health decisions for her at the time that this will was created. The will that she made gave everything to one of her nephews. This nephew had helped her. He had been there as a support for her, cooking meals, providing for her, living with her in her home so that she could stay there longer. As we've got concerns about the validity of the will, and it's our opinion that it would not be valid and we would not be able to prove to the court that it is a valid will, we now need to look at the Administration Act. The effect of the Administration Act is that this individual, her nephew, who was going to be gifted the whole of her estate to distribute between his siblings and other people as he saw fit, is now potentially going to receive a 1/9 share of her estate. That's a significant decrease in the amount of her estate that he is going to receive. He's also been the one doing all of the running around and putting all of the effort in for now potentially a very minor entitlement. Another client that we've had has created a will, written it up for his father, as his father did not speak or write in English. So he's written the will. He's advised us that he's translated the will to his father. His father has said, yes, that's what I want. He's then given it to his father to have signed up, as he knew he couldn't witness it as the executor and main beneficiary of the will. The father then put that in his drawer and kept it nice and safe. However, it wasn't signed. By having the will not signed, it meant it's not even worth the paper that it's written on, especially in this situation where we have an individual who did not speak or write in English. We have no way of knowing that that was his testamentary intention, and there's no way we're going to be able to prove that to the court. The Supreme Court is very strict when it comes to Administration Act and letters of administration. They want to know that the people who are making an application are all of the people, or that all of the people who could benefit from an estate are aware that they could be benefiting from the estate, which is why they require consents from every beneficiary. As I mentioned before, if you're not 100% sure of who they are, where they are, or if there's been a major falling out within the family, this can obviously create some difficulties and some tension. Before we go on, does anyone know what's meant by the term a mutual will?
Isn't that between people that are in a relationship currently or have joint assets, holding and solely joint assets?
Yes and no, perhaps. A mutual will, a lot of people come in to me and say in the meeting, I want a mutual will. When I actually speak to them, they don't want a mutual will. They just want a will that says, I want everything to go to him, and she wants one that says, he says everything goes to her. Basically, they want a will that's the same, just switch the names. That's not what a mutual will is. A mutual will is a separate contract. So it's not really a will, it's a mutual wills contract. And the purpose of that is to define that the wills that we've created today, we won't change unless we let you know and you approve that change. You can include a whole lot of other terms and conditions in a mutual wills contract, but essentially that's what people are looking for. They're becoming more common these days with blended families and second marriages, people wanting to know that their beneficiaries, their children will be provided for. If they pass away, they don't want their surviving spouse or partner to then go and change the will once they've received all of their assets and give them only to the surviving spouse's children, leaving their family with nothing. So they are becoming a bit more common now, but it is important to know that it is a separate agreement between the two parties, and if they are breached, then there are things that the beneficiaries of a will can do, but it is primarily a contractual promise by both will makers that they won't change their will unless both parties agree. To end today, I just want to go through a few other documents which are all part of your personal succession planning. They're not your will, so they don't operate after you pass away, but they're important to consider because there may be circumstances that arise whilst we're alive that we don't have control over. An enduring power of attorney is a document that a lot of people have heard of. However, what they're used for, I find, has mixed and potentially sometimes incorrect understandings. Enduring power of attorneys are only for the finances and property. They do not allow somebody to make decisions for you in relation to your health. A lot of times I have clients come to me and say, I want an enduring power of attorney because I want someone to be able to say how I'm going to be cared for. The enduring power of attorney gives somebody the ability to make financial decisions on your behalf if you don't have capacity, provided they are for your benefit. And if you do have capacity, then they need to be in accordance with your wishes. You can only have a maximum of 2 attorneys at any one time. However, you can allow them to act independently of each other or require them to act together. An enduring power of guardianship is the document that I find people most commonly want when they ask me to prepare an enduring power of attorney. Enduring power of guardianship allows you to nominate one or more people to provide assistance to you so that they can make decisions for you if you lose capacity to make decisions for yourself or you're unable to do so at any given point in time. Whilst you have capacity and you can speak for yourself, you are able to make those decisions. However, if you are unable to, your guardian can. If you appoint more than one guardian, they must act together. They must act jointly and their decisions have to be unanimous. So it's important that if you are appointing more than one guardian, that they get along, or they at least, if they don't get along, that they at least both respect your wishes if you've communicated them to you. Final document that I want to discuss with you is an Advance Health Directive. This is a document which provides a direction from you to a doctor as to how you would like to be cared for if you suffer a certain condition. We can be very specific and list a whole lot of different conditions, However, I've found that clients really want to use this document so that their family members don't have to make a decision to turn off life support or to have any artificial treatment and sustaining measures stopped. The Advanced Health Directive means that you can nominate that if you're in a certain type of condition, you do want certain treatment or not. It overrides an enduring power of guardianship, which means that even if you have appointed guardians, they don't have to make this decision for you. And I'm finding that clients are really interested in this type of document for that purpose. On that cheery note, it's important to know what makes up your estate. It's important to know that you can structure your estate whilst you're alive to give better options or different outcomes to your beneficiaries, and shoring up that your estate will be dealt with in the manner that you want, or that assets fall outside of your estate so that someone can simply take over. It's important to plan and be aware. And finally, it's important to have a properly drafted will. We're here to help, and if there are any questions, we're more than happy to answer them. But I do just want to give you some information. The question that I asked at the start is about death duties and whether they are payable in Western Australia or Australia. They were abolished in 1979. However, the number of people that I get asking regularly in wills appointments and also in estate appointments as to what the costs are going to be to my estate, what are the taxes, how much does probate cost? Telling somebody that going through probate costs them $304 as it is now as a lodgement fee, they're ecstatic. A lot of people are expecting to have to pay enormous amounts of tax, and whilst you might still have to pay some income tax or capital gains tax, there isn't a tax on an estate. Any other questions?
I have a question. It
Yes.
seems like the perfect opportunity to ask a question I've never known the answer to, but I've heard it a couple of times. A scenario where you have a blended family.
Yes.
And primary beneficiaries of each other, but then the secondary beneficiaries may differ, and they pass away at the same time, so a car accident or something like that. The two scenarios I've heard, and I don't know which is correct, the eldest is deemed to have died first, and hence everything passes to the youngest, and then their will takes effect, or there are deemed to be no primary beneficiaries, and each secondary beneficiary applies.
It will depend on how the will is constructed.
That
But if there isn't anything in the will, then generally the eldest is said to have died first. And that's why we will include when we prepare wills, we include a clause that says that somebody has to survive me by a certain number of days, which means that there's clarity as to if they don't survive me, then they're not a beneficiary. Yes.
I've got a question that I know the answer to, but I'm going to ask it because I think a lot of people make this mistake. So if I was to ask you to prepare for me a power of attorney document, and I wanted to appoint my husband,
Yep.
and I gave him this document, and we started to have a few issues, and I gave it to him, but what I wanted him to do was look after my finances when I didn't have the capacity to, really, if something went wrong. Would he be able to use that document now? Because we're going on a month's break or something. And
You said you weren't going to be here, so...
All your money there.
and I accidentally left my wedding rings on today. That's completely coincidental.
Look, the answer is no, he shouldn't be, because he should only be using the power of attorney to do the things that you've instructed him to do. That being said, they are open to abuse, and if you've told him previously, I want you to go and pay all my bills for me, and that situation changed but you didn't communicate that to him, he could potentially be able to still do that for you. Although, why would he pay your bills if you are... But essentially, what we suggest is that if you are preparing a power of attorney, which does not have to be... which a determination as to mental incapacity needs to be approved by the SAT. So if it operates from when a person signs it, that you have the person who you're giving the power to sign the document, and then you take it back off them. Perhaps let them know where it is so that if you do lose capacity, they know where to look. However, that type of document, they don't really need it whilst you have capacity. Perhaps if you were going overseas for an extended period of time and you needed them to sell your property or that type of thing, perhaps that's a different situation. However, unless they actually need the document on a day-to-day basis, I would always recommend that my clients take the document back off their attorneys until they are actually needed. Because they can be a powerful document and they are open to abuse if they're not.
Unless you've got written cited refusal from yourself that it's not viable anymore, we will accept it and they can do
Yeah.
what they need to do.
Sometimes only if they're registered with Landgate.
They will only be accepted if they're registered within the first 3 months of Landgate. So if it is an old one that's never been registered, then Landgate wouldn't accept it for registration.
If you just do a stat dec saying
Don't need
that it
that
hasn't
bank
been
account,
revoked,
sorry.
you just, the recipient of the attorney just signs a stat dec and says the person that gave him this power never revoked it,
Yeah.
and then Landgate will accept it, and it's in. But
No, you
Landgate,
have
that's
to pay
only for
$25
Landgate
fee.
transaction.
Yeah.
164.
Is it?
Yes.
Oh, it's gone up.
I'm 35.
No arguments back here. It's all about money.
What happens if someone wants to contest the beneficiary of a will? So in that instance you had where there was an incapacitated child and there's other children involved, what happens if the other children choose to contest that will?
It depends on the personal situation. That being said, the court does take into consideration the ability of beneficiaries to earn potential income, what their previous history is. For example, I was speaking to a gentleman today who said that one of his cousins, they were the main beneficiary of the estate, and the other beneficiary of the estate was a child who didn't have capacity or was an adult at that stage. The public trustee actually made a claim against the estate because there was no provision for that beneficiary, that child. The idea was that the child that did have capacity, who did receive the full amount of the estate, was going to care for their sibling. That's what they'd always done. They lived together and that type of thing. But the public trustee had concerns because there actually was no provision for that child. Technically, the other sibling could gone off, taken all the money, and therefore not given anything or been able to provide for their sibling. I've also acted on a case where a beneficiary who had no capacity and was severely disabled was completely left out of their father's will. Their father did not appreciate the fact that they had a child who did not have capacity to care for themselves and was physically disabled. The father had not accepted that during his life and therefore did not include them in the will. We were able to successfully contest the will, and before we had to go to a hearing or anything like that, the other beneficiaries did meet with us, and we were able to negotiate an outcome where that beneficiary, the disabled child, did receive part of that estate. So there is a lot of talking behind closed doors and in mediations before anything does actually get to a full hearing or a trial. There can be a lot of deals done and agreements made between beneficiaries if somebody isn't adequately provided for. So it can be worked out, and hopefully it can be worked out without having to go to court and then making a decision.
Yes. Try to get this out right. Regarding executors, is it common and or recommended or not recommended that major beneficiaries are executors of wills And what are the main duties potentially, or disastrous duties that could occur of being named executor?
It is common that major beneficiaries would be named as an executor. For example, if I'm preparing a will for husband and wife and they've got 2 kids, let's go the perfect world, everything goes to the husband and wife, and if one of them passes away, then the estate goes to the children. Often we'll suggest that the husband or wife becomes the executor, and then in the event that one does pass away, that the children are joint executors. The reason that we'd suggest that the children are then joint executors is because you then don't have one who has more control or power than the other. Your executor is responsible to your beneficiaries, and if they aren't acting properly, there are steps that the beneficiaries can take to either have them removed or require them to provide information to them. However, it's obviously more cost effective if everybody is upfront and gets along. So generally, if it is something that's possible, we would suggest that, you know, if it is that situation that there are the 2 children, that they are joint executors, because then they're also aware of what's going on the entire time. They both have to look at things, they both need to sign off on everything, so they are both aware of the situation. That being said, it's sometimes not practical for that. Perhaps the beneficiary lives overseas, or they don't have that ability. It's just something that they would struggle with. In that situation, if somebody does have concerns about that, that's when we find that they would appoint us, Lynn and Brown, as the executors, so that they know that there is that independence and that everything is going to be done properly. As you do have responsibilities to beneficiaries as an executor to provide them with full accounts and keep them informed when it does come time to distributing the estate.
Quick question. How long does a beneficiary have to contest a will? Or if you're not a beneficiary, perhaps?
Generally, the rule under the Family Provision Act, so that is a legislation which applies to certain classes of people. So family members, so children, if they were left out of a will, for example, they would have 6 months from the date that probate or letters of administration are granted to challenge the estate through the Family Provision Act. There is time that, you know, if there is a situation that it was impractical or not able for them to be lodged within that time frame, the court can extend that time frame. That being said, there have been examples where a lawyer lodged the documents 3 days late and the court has dismissed that application. That wasn't in Western Australia, that was in New South Wales. But it is important to be on time. There was no other reason other than the lawyer being a couple of days late that this application was not lodged. However, that there was also no reason why it couldn't have been lodged 3 or 4 months earlier. They were sitting on it. And so with that information, the court said, well, look, too bad, you missed out. So,
and I assume that timing would dilute based on the family lineage and...
No, it's a 6 month. If you're somebody who that act applies to and you would have a claim, then you have a 6 month period. Any other questions? Ali?
So applying for probate costs $300. Is it similar for letters of administration?
So that's the fee of the Supreme Court at the moment. May go up July 1. Do you know if it goes up? Haven't heard anything yet? Yeah. So that's what it costs at the moment to lodge with the probate office. If, you know, for example, you're getting us to prepare an application, then we do have our fees on top of that. But it is only an administrative fee that the court charges.
What if 2 guardians don't get along? So situations have changed over time.
Depending on your situation, so if it's that you've nominated them because of a period of illness that you didn't have capacity, you now do, then you could change that nomination. There could also be an application made to the State Administrative Tribunal, and there would need to be evidence shown as to why one perhaps was not the correct guardian or the other, or that there had to be somebody completely independent appointed because they could not get along.
If If an enduring power of attorney has got access or can make decisions regarding your finances and real estate, could they then make changes to a will based on finances and real estate?
They could potentially make changes to the effect, to the gifts within a will. So, you know, if we had a bank account that had $200,000 in it and the attorney was going to act improperly and decide that the person needed a boat when they didn't, you know, but the boat was put into their name because, again, they're obviously acting improperly, that obviously there's then going to be a watering down of the size of the estate, but you can't actually change a person's will as an enduring power of attorney. Yes.
That leads me to ask the question, and I won't say whether I know the answer or not.
You're just testing
whether power of attorney or power of guardianship, does it have any weight after the person I have the power for? I've been nominated attorney or guardianship of someone. Does that have any effect after that person dies?
No. Once a person dies, they're invalid. That being said, I do know clients who have used them after they have, obviously not the guardianship because that's probably not relevant, but that have certainly used power of attorneys to access bank accounts after a person has passed away. So the answer is no, but if the bank's not told that a person's died, they can't take the appropriate action.
I've got another question. This is one I truly don't know the answer to because I haven't done the research. In Victoria, we have a database at the Supreme Court where anyone who's applying for filing an application for probate or letters of administration, previously you had to lodge an advertisement in the newspaper to let the world know that you're intending to apply. And the purpose of that is to let those beneficiaries...
All the people who read the paper.
Yeah. Let the beneficiaries that want to know whether they've been included or potential beneficiaries to see, you know, did mum and dad leave me out because they stopped talking to me 2 years ago. It used to be done through the paper. So people would manually have to go through the newspaper every day in a law firm, just in case someone was interested and they wanted to know whether someone had applied for probate. Now we've got it all in one central database at the court. So your intention to apply for probate is lodged on this website. How in WA do you know if someone's going to apply for probate?
You would need to do a search, whether you would be able to get access to that because you're not somebody who has made an application, would be limited. Essentially, if you are a beneficiary and it's under the Administration Act, you do need to, your administrator needs to make sure that they are certain that all persons who have been, who are potentially beneficiaries are notified and have consented to the application. So that's actually the administrator's obligation. If there's a grant of probate, which we're looking at preparing, then the person would make an application. So there's no need to do a search.
And perhaps we're a bit smarter in WA and we do realise that people don't read the newspaper, so we don't bother with requiring people to advertise it in the newspaper.
Also, if you want to, if you want to contest a will, maybe you should be interested in the person. Well, it's not potentially somebody else's job to go and tell you that there might be a will you might like to contest.
There's no way, if you don't know someone's died, how do you know? That's what this database in Victoria does, so that any time you can log on, anyone in the public can access it, log in and type in Blakeman Megan. Has anyone applied or intending to apply, because there's the intention to apply, for a grant of probate under my name? And by doing that, they'll know firstly whether someone has died, because you can't apply for it without someone having died, so then you know I've died, and you know what date I've applied, which gives me notice of how long I've got left within those 6 months. But this is nothing, is it, in WA?
No, you can't do it here, but maybe if you don't know the person well enough to know if they've died, maybe you're not really shouldn't be making a contesting of them. If you think they might have died, you make an application to the court, and the court will tell you whether an application has been made. Or you can make an application to the registry to see whether they've had the registry of births, deaths and marriages to see if they have died.
So you can search the probate books as well. So we used to do that.
You can apply to the court.
You can
yeah,
apply.
you apply. You lodge an
yeah.
application with the court.
So you can go to the court.
Oh, what? Not me. I'm good.
Well, you were asking.
Okay.
No, I figured in WA we just put the notices in the form because most people read that. So. Or like the footy pages.
Footy pages.
You do like Ali's search,
I think hopefully by the questions that were asked there was a bit of interest. And
that's an ad buddy.
yes, the bad people up the back. I think we started with that and we'll finish with it again, that were rudely interrupting us. But thank you very much for coming tonight. And I'd also like to thank Elise, and perhaps if we can thank her in the traditional manner. I think it was a really informative and interesting presentation. As you will see, we have the next part of our seminar series on the 19th of July. Sterling, who was here and has had to step out, will be presenting on consumer law. So we are all consumers, and if you've ever had a concern about when you are purchasing something and the law that may relate to it, you will learn a lot more on the 19th of July in relation to that subject. In the package in front of you, there is a short questionnaire which we would very much appreciate you completing to give us a bit of feedback on the presentation and the topic and future ideas for us to present on. And thank you very much for coming. We would love for you to stay and have a drink and have a chat, and you would know myself, Jackie, Elise, Megan in the room who are available for answering questions that you may want to personally approach us with. Thank you again.